the presentation to.
Sorry about that.
Good morning. Welcome to the CCMF Legalese workshop, or Understanding Legalese. So this presentation is designed to give you a sense of, first of all, why legal language is so complicated and annoying. Second of all, some general operating principles to deal with legalese when you're receiving it. And then thirdly, some principles for how to write when you need to communicate with the legal system, whether it's with a judge or opposing counsel. And then at the end of it, I'm open to questions. So, and I also just want to acknowledge at this time how deeply difficult the legal system is for men. Difficult is an understatement. The biases are extreme, and the suffering that I witness in our membership, just from the fact that you all are men trying to navigate this, is extreme. So I want to thank you for your forbearance in dealing with the system, and thank you for showing up this morning, and also thank you for just the way you keep going day after day. It means so much. We live in an atmosphere of extreme oppression and persecution, actually, often just based on the fact that that you're men in a system that reads men persistently really badly. So send out strength to you. And this presentation is designed to give you some tools to navigate the system better, but it is a broken system, like a rusty piece of playground equipment that's dangerous, but there are some ways to navigate it that increase chances of success. So I'm going to share the screen. I have a PowerPoint presentation, and these principles are distilled from my 3 years of law school, 2 years of doing a master's of law degree. And what I want to say is I'm not a practicing lawyer. I made the conscious decision not to get called to the bar, in part because I don't like what the legal system does to children in particular, nor what it does to men. So these are principles based on my study of the legal system, but this does not constitute legal advice. So without further ado, let's bring up the PowerPoint presentation. Right. So the question that this presentation is trying to pursue is, why do lawyers and judges communicate in such an annoying and complicated way? And then later on in the presentation, we'll explore what to do in the face of that annoying complexity. So the first part will be explaining a little bit about why legalese is so complicated and annoying. The second part will introduce some operating principles for dealing with the complexity and annoyance, specifically ways to endorse your own intelligence when you encounter legalese and feel stupid, which is common. It's kind of the common experience of law school, is always feeling dumb compared to the law. So you're not alone if that's your experience. The second principle is to ask for help. So have the humility to ask for help, including from fellow CCMF members. And I'll go over some ways you can do that. And then finally, using all available resources. And I'll share some of those resources, including some info about CCMF's online legal clinics. And then finally, we'll go through some principles about how to write legal materials effectively. Why is legal language so complex? It is basically because Canadian law derives from the English common law, which has a 1,000-year history of being embedded in the English language. And English is a weird melting pot language. It has words that come from its base of Anglo-Saxon, but also Scandinavian words that came from settlers who came to England in the 9th century, and words from the Normans who spoke Old French, who conquered England in the 11th century. And so because our law has grown up through this 1,000-year history, there's weird, I would say, relics, like linguistic relics in the way law frames things that make it seem complex. It's not really complex, but it's just reflecting this history. So I'll give you some examples, like There's often 2 or 3 words that are expressed in legal language that mean the same thing, but you wonder why they're there, like will and testament, or goods and chattels. These kind of old words like chattel, like what does that even mean? Or give, devise, and bequeath, purchase, buy, possess, and own. And it's because in the early history of the English common law, there'd be people with different linguistic backgrounds. So if the law was trying to speak to everybody, it would use a bunch of different words. So some of that formal, like almost medieval flavor survives in a lot of the ways that laws are written. And then because laws are written that way and lawyers and judges go to law school, they kind of develop this way of writing that it doesn't reflect reality, but it reflects this history of English. So if it seems weird to you when you read legal materials, it's because it is weird, because English is weird. We're weird people. The other reason why legalese is so complicated is because lawyers are mostly terrible writers. They mask it through a lot of complexity, but most lawyers didn't ever figure out how to translate complex terms into simple language, which means they're actually crappy writers, but they sort of give this appearance of being smart, which they're not. And most lawyers and judges, there are some glorious exceptions, but for the most part, they have very little real world experience, which makes their language unnecessarily abstract and out of touch with reality. And that makes it difficult to understand. So if lawyers' language feels out of touch to you, or if judges' decisions feel out of touch, it's probably because they are. So trust your instincts on that. It's like a lawyer will talk about something without actually really knowing the emotional flavor of it or knowing really what it is. So just using all these abstract legal concepts to talk about something that you could talk about directly if you had real world experience of it. And then the third answer why legal language is so complex is that lawyers deliberately use language as a weapon. And so they'll use unnecessary complexity as like a way of flexing their intellectual muscles so that they seem smart, often because they're very insecure and don't feel that smart, but they'll pretend to be smart by using a bunch of legal terminology to intimidate you. And especially if you're a self-represented litigant with a high conflict X, often their lawyer will like weaponize language and weaponize your lack of expertise to intimidate you. So in the face of this, I feel that a sound strategy is to simply acknowledge that the language is an attack. So if you read some communication from the opposite party's lawyer, or even if you read a judgment and it feels confusing, often it's because it's an attack. There's ways that judges will like attack men through their judgment. So if you're reading it and it feels like an attack, it's often because it is. That's not necessarily good news, but I feel like acknowledging reality at least puts you back in touch with your own instincts. So if you think this person is messing with me, probably they are, and just acknowledging that will free up headspace to see what's going on for what it is. So yeah, legal language is complex because it's rooted in English, which is a weird melting pot language. Lawyers are bad writers, and often so are judges, and language is deliberately weaponized through intellectual flexing designed to mask insecurity. A lot of lawyers have like really big egos, but actually extremely low self-esteem, and that's reflected often in their use of language. So what do we do in the face of this? I'm going to discuss 3 operating principles. The first is to endorse your own intelligence. So if you feel frustrated trying to understand legal language, I want to recommend that you actively endorse your own intelligence. And this means you might even be saying things in your own head like, I'm smart, I know how to understand this. Or if you come to understand something you didn't think you could understand, like in your own head, pat yourself on the back. It seems, what's the word? It seems overly simple, but one of the first things that happens when you come up against some piece of writing that you don't understand is you start to doubt yourself. And maybe, I mean, all of us have various experiences of feeling not smart enough to deal with what's thrown at us, whether it's in school or people through our lives have used like attacks on our intelligence to make us feel bad. Maybe your ex even did that, like questioned your intelligence. So you don't have to have a law degree or a PhD to recognize yourself as smart. True intelligence for me comes from being in touch with reality. So whatever your educational background is, just to be like I affirm my ability to understand reality. So you don't have to have any specialized training. You just have to like not doubt yourself. It doesn't mean you have to understand the legal language that's coming at you right away, but make an active effort to build yourself up in exactly the place where you're being attacked. So the opposing party might be attacking your intelligence because they know that's a vulnerability of yours. So counter that by just actively celebrating how smart you are. And if you're still alive, you're actually quite smart because it takes a huge amount of intelligence just to survive, especially if you've been thrown into a legal battle with a high conflict ex. And that can mean, just like you acknowledge that the legal language can be a weapon, you can also acknowledge your own feelings of inadequacy, or even the ways that you might feel dumb, and just say like, I acknowledge that this is how I feel. And sometimes just facing that reality opens up more energy to deal with what's in front of you. Operating principle number 2 is to ask for help. So practice humility. If you don't know, ask. And fellow members of CCMF can help with this. So there is a way that legalese gets easier to understand the more you're exposed to it. I went to law school late in life, like when I was 38, and the first year was torture. And one of my professors described the first year of law school as like trial by text, I think she said. And it's just being thrown a bunch of complicated language, all of it that made me feel really dumb. And then it's just, the more I was exposed to it, gradually it clicked in. And this has been the experience of lots of members of CCMF who've had to be self-represented, or had to do a lot of the work themselves, even if they had a lawyer, is they've come to understand some of what's going on in the legalese over time. So I encourage you to rely on each other as this. So if you feel like you have some understanding of legalese, you can volunteer some time to help other CCMF members. It's something you could bring up in one of the support groups or the legal clinics. Gavin has kindly created this group on Matchin called the Ready Room, where you can connect with other men. And I want to suggest that that's a place where you could ask questions about legalese, or you could offer your services on a volunteer basis to other members, and or arrange to meet outside of established meeting times just to help each other out. And often when the material is traumatic, which it necessarily is if you're involved in a legal battle, even something that's simple will be hard to understand because it's hard to accept that this attack is happening. So sometimes if somebody's one step removed and it's not their ex's lawyer writing the attack letter, they can help you understand it. And the other thing that happens when you have a traumatic response is your intellectual capacity narrows down because you go into a freeze, flight, or fight mode, and you often only see a very narrow range of possibilities. So just acknowledge that that's going to be real anytime you try to interact with legal documents. So sometimes having a friend, even if it's not an expert who can help you, like, makes a big difference. So let's rely on each other for that. Operating principle number 3 is to use resources that are available. And that's the other thing that happens when you have a traumatic response, is you all of a sudden feel alone, and like the available options are very narrow. And probably all of you have had poor experiences with the legal system. I don't know how you couldn't have. And that means that anything to do with law or the legal system seems like it's probably not going to work. It's probably over complex. It's yet another website to go to try to navigate, and it seems hopeless. However, like there are some resources out there that can help. Like if you have a legal aid certificate and sometimes you only get 2 hours, you could use that time with the lawyer to ask for clarification on key concepts or key aspects of the legal procedure. And that way you use the time with the lawyer to educate yourself. Most courthouses in Ontario and BC, those are the only jurisdictions I'm familiar with, but other jurisdictions I think also will have a family law resource center where you can go and ask for help. It's going to be limited and frustrating, but just asking questions. Sometimes you even have to like, how do I put it? Like fake humility, even if you are burdened by the process and really frustrated, just going with, oh, thank you, sir. Thank you, ma'am. Thank you so much. I don't know what I'm doing. Like sometimes what I've noticed is it's often the strength in men that is threatening to the legal system and people who work in it. So even if you have to put on a disguise of, I don't really know what I'm doing, can somebody help me? That will often get you resources, even though it's not necessarily, I don't know how to put it, the most manly way to be, but sometimes that's what you need to do to get the help. Sort of playing the victim seems to be what's legible in the current system. So don't be afraid to be humble and ask for help as need be. I'm going to put in the chat a link to register for CCMF's legal clinic. So you can always show up there, take 5 minutes to ask our legal clinic lawyers online for clarification about documents. Usually they'll be happy to do that if it's family law related. And then I also have a list of legal resources in BC here and here. So if you want me to share those Google documents with you, maybe pop your email in the chat and I can share those with you. Just some free legal services and legal education materials. I'll also share them on Mansion. Okay, so these 3 principles, endorsing your own intelligence. Let's go back. So we have endorsing your own intelligence, asking for help, clarifying, especially if you notice that you're having a trauma response, which you almost inevitably will be in navigating the legal system, and then opening yourself to resources that might be available, even if it feels like there aren't any. And now we'll move to the 3rd part of the presentation, which is how to write effectively. And a series of principles. First, don't mirror legalese. This is a common mistake that self-represented litigants will use, is that you see the way the opposing party's counsel is speaking, you see the way judges speak, and you think that you need to seem smart. So you try to write like a lawyer, but it's generally not a good idea. It's not even really that great when lawyers do it. And you're probably not going to do it well. And if you try to do it, it'll just introduce unnecessary complexity. And judges will generally appreciate clear, plain explanations over excessively complex ones. So you don't need to try to be what you're not. So you don't have to pretend to be a lawyer to navigate the legal system well. Whenever possible, just say it plainly in your own words. So don't mirror legalese, principle 1. Principle 2, be appropriate, which means choosing the word that expresses the tone you want it to convey. And again, checking with a friend to make sure your tone doesn't seem like too much like a weapon, like you're going into battle. And even if you don't feel this way inside, try to make your communication seem peaceful, kind, whenever possible, even if you feel like you need to meet attack with attack. The main purpose of any communications you do with the opposing party or with the judge is to clarify the issues, put the judge at ease, and just give the impression that you're reasonable and sane. And I would say that applies not just to the legal communications, but to everything, like anything that's traceable, any emails with your ex, any texts that you write, you're always trying to give the impression of being reasonable and sane. And then find somewhere else to express your emotions. So there can be a temptation to want to tell the truth in court. And by that, I mean like express yourself, be heard, have a voice. And that's an important thing to want, but it's often not possible in the legal context. So trying to like be seen and get your whole story out and like express yourself is often the wrong instinct. You just want to clarify the issues, ask clearly for what you want, and avoid using the legal documents as an avenue for self-expression, if that makes sense. Principle 3, be concise. So use the least number of words necessary to make your point. Use short, clear sentences. Again, a lot of legalese uses long, complicated sentences. Don't mirror it. Like when in doubt, put the period in there and then go on to the next sentence. And whenever possible, use simple words instead of complex ones, even if you see complex ones coming at you from the opposing party. Principle 4, be direct. So there's all these convoluted turns of phrases that you'll often see in communications from lawyer, like at that point in time. And so instead of saying at that point in time, you can just use then, or like in the present circumstances, you can use now. By reason of, just use because of, despite the fact, although, and so on. So whenever possible, just go the direct route, like when my ex did this, instead of at the point in time when she did this. So looking for, and this is another way where having a buddy or a friend, maybe through CCMF, can help you to just get rid of these unnecessary things. Because the easier you make the judge's job, the more they're going to like you. So cut the unnecessary complexity. And there's also a strength that's conveyed in directness. And then also, again, all these weird twin words that appear in legalese because of this history of like the Anglo-Saxon and Old French interaction. You don't need to use that in your communications. Like you don't have to use alter or change, even though you'll see that in contracts and other communications, or cease and desist, force and effect. It's not necessary to do that. You can just be direct and use the simple word. Principle 5, and this in a way contradicts what I was saying before about not using the court as an avenue for self-expression, but it's about believability. So be yourself. So write in a way that's true to yourself. Like if you regularly write technical reports as part of your job, for instance, don't feel like you have to do anything fancy, just like straightforward, true to you when you do the writing. But consider the tone and the point of all your communications, which is to appear reasonable and sane, and suppress the urge to use legal communications as an avenue for undisciplined self-expression. You might, if you feel threatened by legal communications, or you feel like your ex and the opposing counsel is threatening your intelligence, you might want to retaliate by seeming smart. So you might want to say, these people are making me seem dumb, I want to seem smart. That's an understandable reaction, an attempt to preserve the ego in the face of these attacks. I would like to caution against trying to prove your intelligence, because the judge really won't care if you seem smart, which is unfortunate, but the judge really cares if you seem like a reasonable person willing to go along with the program. I would also caution against relying too much on ChatGPT. You can use it maybe to draft a letter, but it can come across as insincere or out of character if you don't go over the product of ChatGPT and make sure that you personalize it, because you want your communications to seem like they're coming from you, not from some AI alter ego, because that could come across as weird. Principle 6, ask for what you want and root the ask in authority. So when you're communicating with a judge or the opposing party, just be clear on what you're asking for. And again, you can just ask for it directly, like, I'm asking to vary the current parenting time order in this particular way. Not using too much legalese, just direct ask. And then you want to root your ask in legal authority, which means that you need authority for the procedure. So if you're in Ontario, it might come from the family law rules if it's a family law matter. So you have to have like authority for doing the thing that you're doing, and you also have to have authority for the particular thing that you're asking for. And that comes from statute and supporting case law, which brings me to the final point, which is just like, and forgive me if this is too obvious, but I feel like it's good to define what law is in general. Because if you know what law is, that will give you a sense of how you need to appeal to legal authority to justify your ask. So at its basis, law is a set of regulated procedures determined by formal rules like the Ontario family law rules or the rules of civil procedure, but also determined by convention. So this is the whole long 1,000-year history of English common law, how things have come to be done. The convention is a little less obvious. You feel like you're stepping into some weird alternate universe when you step into the legal world. And those are the conventions. So law is like the procedures, and it's a body of rules. So that's the substance. So it's procedure and substance. And the rules are determined by statute. Those are the laws passed by government, so municipal, provincial, or federal. So like aspects of the Family Law Act in BC, for instance, those would be statute, but it's the interaction between statute and case law or precedent. So decisions that judges have made give an indication of how the statute should be interpreted. When the legislature drafts statutes, the statutes are deliberately a little bit vague and not clear to give room for judges to interpret the statutes, and that gives some flexibility. So what the law is ends up being an intersection between statute and case law, and that gives wiggle room. So you can argue for one interpretation of the statute, whereas the other party is arguing for another one, and the wiggle room between the two gives the judge the room to decide. I could go much more into this, but I will not. So in summary, legal language is complex and weaponized. You can fight back by endorsing your own intelligence, by asking for help, and by using all available resources, and acknowledging that your own trauma response will often make the available help and resources seem much narrower than they are. So rely on the CCMF network for help. And often, even if your life isn't perfect, there's something that you may have learned along the way that can help somebody out. So let's lift each other up. And then finally, just maximize your chances of success by mastering some of the legal writing fundamentals. Don't mirror legalese, be appropriate, watch for tone, check it against a friend, just be concise, don't use too many words, be direct. Again, don't go the roundabout way, go the straight way. Be yourself up to a point. Be as much of yourself you need to be strategic, but don't look to the court to be the place where you can express everything you want to say. So find somebody that you can talk to, who you can share your truth, so you're not asking the court to hear you, because usually they won't. That's the sad state of affairs in terms of the court's persistent misreading of what men are, and dislike of masculinity, actually. And then the sixth principle is to ask for what you want, but make sure that you justify the ask by referring to appropriate legal authority. Okay, that is it. Any questions?
That was amazing. Thanks very much, Kristen. Just before we kind of go to questions, just a couple of quick things. I think what you mentioned about affirmations is critically important. And sometimes you have to say it to yourself like 100 times when you're driving to court. Like, I'm not crazy. I'm actually really intelligent. This is crazy. I'm logical. I'm not crazy. I'm actually really intelligent. This is crazy. I'm logical. And like just repeating that affirmation in your head can sometimes talk you into a better headspace. Second thing is, if you are attending court, sometimes attending court for someone else in advance will help address some of the anxiety of being in court for yourself, and almost normalizes some of the verbiage. You get used to hearing that legalese and think about ways that you might be able to respond to that language in advance of attending court for yourself. And I guess I think almost everybody here has an account on Mansion, but all the legal clinics are posted on Mansion in the events, under the events tab. So if you want to attend a legal clinic, all the links are there. And then the last thing, so we built kind of a legalese dictionary on Complex Trauma Canada in the members area. And if anybody would like access, I can give you a link and you can set up an account and access all the family law and criminal law resources, including the simplified legalese dictionary that's listed there. If you're interested in that, just you can either send me an email, respond to one of the ones that I sent you, and I will send you a unique link so you can set up an account with Complex Trauma. That's all for me. We'll kind of open the floor to questions now. If you could use the raise your hand function, I'll do my best to kind of keep track of who's going in what order. Does anybody have any questions for Kristen about either legalese or about the presentation itself? We still got people connecting to the meeting. Kristen, when you were talking about rooting in authority, can you kind of explain what authority means in that capacity?
Yeah, so like let's just use an example. I'm going to pull it up on the screen. Okay, so just share screen.
Just while you're doing that, Aslam, I see your question in the chat and we'll address that question afterwards. If anybody else has questions they don't want to verbally ask, if you want to just put that question in the chat, I'll do my best to monitor it and ask Kristen the questions. Thank you.
So say, okay, this is just simple. Like the reason you're allowed to appear as a self-rep is because, like in Ontario, I'll just use the Ontario example. These are the Ontario family law rules. So Ontario family law rule 4, like, where is it? Where did it go? Ontario family law rule 4 sub 1A says that a party to litigation may act in person, which means that you're allowed to act on your own behalf and don't have to have a lawyer. So that would be like the legal authority at a procedural level for why you're allowed to represent yourself. So that's at a basic, or if you want to figure out where the case starts and it's to be heard. So like, we'll say like the Courts of Justice Act dictate that the case starts in the municipality where the party resides, generally speaking, or if it deals with decision-making responsibility, usually in the municipality where the child usually resides. And then there's exceptions. So that would be like the authority for where the case is going to be heard. So there might be, if you're doing different kind of things, you might need to appeal to different of these family law rules in Ontario to justify why you're doing what you're doing. So that would be like authority for certain procedures, as an example. I see Brian's hand up. Oh, I think you're muted, Brian.
Yeah, there we go. I actually know Gavin quite well. Thank you for putting this on. I've actually challenged the court a few times. I have a mild brain injury, PTSD over this as well. I was blindsided, and there was no help at the beginning. Have you heard of anyone challenging some of these rules? Like, I don't know what it's out in BC, but there's supports in place for people, and mental health is a disability as well now. Have you heard of anyone challenging some of this stuff? Like the way to communicate, like, for example, I was able to communicate in email, like send, and, not bypass the paperwork, and all this stuff, and present it through email, or have supports like there's something called a communications intermediary, where the court has to provide services to people, to anyone, if they don't like that are struggling, especially when you get blindsided like some of us have, and it's not fair. I don't know if you guys have a court support person in BC, but in Ontario, I'm challenging that as well, because the court support person will help you with the paperwork. Unfortunately, in Ontario, half the places in every city is run by female-led organizations, and a large portion of those will not, including the one in the city I'm at, will not help me because I'm a man. And that's not cool. And I struggled and it actually hurt me, because I didn't know what was going on. I had no clue. And so I just didn't know if you've heard of other situations where, trying to, like, with accommodation and stuff like that, where and with new accommodation and stuff like that the courts are behind. Criminal court is actually further ahead than family court on some of this stuff, but like, even challenging litigation, like, why should I have to be, like, I have a choice, why should I have to be dragged through litigation when we should be able to try mediation, or be able to try restorative justice, or be able to try, right? And that's kind of where I'm at. I guess I just have some questions, you know what I mean? If you've heard of anyone ever challenging this and realizing I've had some success in doing that.
I don't have enough experience to have heard about that directly, but it's at least one of the, and the legal system contradicts itself all the time. One of the things that the legal system says it's committed to, especially in recent history, is access to justice, which means making appropriate accommodations for people who have difficulty accessing justice for reasons of, disability. So appropriate accommodations should be made. Whether that actually happens in fact is a completely different matter. Generally, probably not. And there are way more resources, like exponentially more available to women than to men. And the other problem is often in family and criminal contexts, if you have a declared mental health issue, or even declared PTSD, or declared brain injury even, sometimes that can be construed, which is quite sadistic, I feel, as something that makes you unfit to be with your children, or makes you more likely to be seen as not a credible witness in a criminal proceeding. So I like the idea that, like, if you have some access to justice issue that's legitimate because of a mental health issue, or I don't know who couldn't have PTSD from dealing with the legal system and family law breakdown. It's like, it's almost the fact. It's often disadvantageous to men to admit that. So, because the levels of empathy that people extend to men are almost non-existent. So you say you have PTSD, all of a sudden, oh, you're a violent guy. And so often you have to, this is what I mean about being careful about expressing yourself. I wish it wasn't the case. I wish you could say, look, the experience of having been separated from my kids for this amount of time has devastated me. And it's hard for me to go about my day. And I don't know what to do. I feel so crushed by this. Can somebody help me? I can't even read anymore because my head hurts so much from like just the experience of, even just the experience of all the attacks on my character from all the people in the community that the exes alienated me from. But often that's not to your advantage. So it has to be this performance of being okay, even when you're not, just to get a strategic advantage, which I think is unfortunate. So that's why, for me, I think it's, you have a couple of trusted friends, maybe people you know through CCMF, who you can privately express your distress and despair to, and who can help you with the legal documents so that you don't expose yourself too much to people who don't have your best interests in mind.
See, and I was attacked right at the start of my brain injury or mental health. First, it was domestic, and then it was something else and something else. You know, I was smart enough to realize I've been to this dance before, to take a step back. And I know, like, using CAS and then having them investigate it and then them closing the file. I really believe that putting those, and whether it's right or wrong, this is how I feel, that as long as you're getting, and this happens in criminal all the time, as long as they can see the steps, or even in CAS, if they can see the steps that you're using and you're taking in order, even though the situation, PTSD, you know, this caused it, well, it's in the best interest of the kids. But if you are actually taking courses and, you know, even though it's happening and you're actually doing things in a positive light, I think reaching out for help and talking about it is a sign of strength. And, you know, and I'm not going to, you know, right. So yeah, I would rather have me bring it up than her twist it and bring it up a different way. And so, and I think Brian Lubner mentioned this before, that you peel away the onion and you volunteer to take the anger management, or if there's that's a concern, or you take a parenting class or two, you know, like and those are just good strategies too, because when you're in this funk, it does affect your ability to parent. And so I'm just a big believer in that, and I think actually the court is mindful. You know, most judges are mindful of that and aware of that. Right. My problem is how I communicate in court. by a, like right, like, but that's not how I am with my kids. But anyways, I just like I said, I'm a big, I think the one gentleman a long time ago said, and he's right, if you might lose some battles, but stick in it and you'll lose the war. And yeah, I've had, some success with that and seeing my kids more and, turning over, seeing the true colors by you take a step back, you take your courses, right. And you get help and just kind of having support like CCMF and I think that shines through with judges. I would hope it does, right? Because yeah, so I guess my other question, how common is this on cases high conflict? Like how these judges have to see this stuff time and time again, would you not think?
Yes, and I would say it's good to be like getting help and being able to document the ways that you're getting help. And if anyone is coming to the men's peer support group meetings and needs a letter from me to give to the court to show that you've been coming to meetings, I'm happy to do that. So just send me a letter to that effect. But it really it depends on the situation, Brian. You would hope that the judges would act in good faith, but our experience, kind of collective experience at CCMF it's often not the case. And exactly when you think, well, I'm doing all these things, I'm helping myself, this should look good, it doesn't necessarily mean that's the case. At the same time, like if you're doing things that are legitimately good for you and improving yourself, like taking the parenting course or getting the supports that support you, that's good to do for yourself anyway. But we can't say with confidence that the judges will necessarily look on that. Well, it's very case by case.
So I think a couple of things. One, I want to get to Aslam's question in the chat, and there's a couple other questions posted in the chat. There's a press release that we're sending out tomorrow morning, which deals specifically with the lack of mental health treatment administered to judges who are at risk of kind of ingesting vicarious trauma because they've dealt with so many high conflict cases again and again and again, and all of a sudden they lack, they suffer from empathy fatigue, they suffer from burnout, and they look at you as a number instead of as a person. So trying to address the judges from a mental health perspective, I think, is important, and having a little bit of empathy for, as Brian said, the fact that they see these things day in and day out. The judges are human beings. They're probably trying to do the best that they can, but when you just see this stuff again and again and again, it's difficult to kind of maintain that level of humanity. But I want to get to Aslam's question. So I'm not sure if we can give you a direct answer on this, Aslam, because it may constitute legal advice, but I'll read it out to Kristen and she can respond. So Aslam says, I have a condition in my peace bond to, quote, not communicate directly or indirectly with my wife, except pursuant to a court order or court proceeding. So if I have this condition, and since I'm representing myself in family court, can I send her court form documents through email or send her an email to get the court date the way it works for both of us? Be able to address that?
I'm not able to give a clear answer on that because I don't have sufficient familiarity with the family law procedure to be able to say, but I would recommend coming to the legal clinic on Tuesday night in Ontario and asking Jean-Jacques about it, or I don't know where you are, if you're in BC, come on Wednesday nights and ask Carrie, because they'll be able to answer it. I'm not called to the bar, so I'm not able to give.
Yeah, no worries. Thank you. Yeah, I will join Tuesday then.
I can give a guess, but I don't want to do that in this context.
No, that's fine. That's fine.
Okay, so RJ asked if the meeting will be posted. Yes, the video will be posted on Mansion. Michael says looking for legal help and resources for an appeal at divisional court on false allegations against us in a civil case. Michael, I think I'd probably, and I think Kristen would probably say best advice is to join either Tuesday or Wednesday nights. Alberta also hosts on Thursdays. I'm not sure where you're located. And someone else posted, are there online courses for anger management and parenting skills that are acceptable in Ontario courts? I don't know the answer to that question. Kristen, do you know the answer to that question?
I think there are, but that's a good thing for me to know more about. I know we've had CCMF clients in the past who have taken some anger management courses, and our CCMF York office, we're not calling it anger management. I think it's called, can't remember, emotional management, something like this. But there was a program offered out of CCMF York, which I think is still going on, that provided something like an anger management thing, but I'm not sure exactly which courses are approved in Ontario. I'll have to look it up.
Yeah, sorry, that was me that asked that question. The reaction button is not showing on mine, so I can't put my hand up, and I apologize for interrupting. Yeah, I did find something online. And it claims to be acceptable to the courts, but I'm always leery of claims on the internet, and so I just wanted to know if you guys knew any successful ones.
Brian says that John Howard Society has a list of courses for anger management. Thanks for that, Brian. I'm also seeing a question in the chat about how to get an OCL report struck. You can file a motion to do that, but the OCL, is this meeting being recorded?
Yes, it is.
I won't mention my thoughts on the OCL in a meeting that is being recorded. But let me just say, it's not surprising that you would have had a difficulty with the OCL. The OCL needs some serious guidance when it comes to properly evaluating the realities of female perpetration and the threats that high conflict mothers pose to their children. And they don't seem very literate in knowing when children's testimony is being manipulated to the advantage of an alienating parent. You can bring a motion to have the OCL report struck. Whether it's successful or worth the costs, both financially in terms of time, is another matter. I applaud you for taking it to the ombudsman. And I'm sorry you've had to deal with that. It's not surprising, unfortunately.
Yeah, I'm going to stop recording the meeting at this point. And then maybe we can have some more candid conversations.